I'll begin by expressing my dismay to the humiliating body search that I was subjected to twice, and all members of the legal profession were subjected to. First at the gate, then as we entered the courtroom, another body search. And I'm asking the officers, between the gate and here, and most people have left their briefcases at the gate. What would make them subject us to a second body search? Secondly, I have not yet had audience, the right of audience in court, because I'm not yet licensed to practice in Uganda. I'm expecting a special license to be issued by the Law Council. It has been indicated, I applied last week. I was informed that they do not process digital applications. So my physical application was brought on Wednesday, and it was taken by the law firm of Lukwago and Company. And it has not yet been processed, but I have been promised by the chair of the Law Council, Justice Muliagoja, that we may hear from them as.
Okay, welcome again to my YouTube channel. If it is the first time to view this video, this is MIKEANN'S reaction, and I'm very glad with you guys for your great support each and every time. For my returning viewers, I want to tell you that you are in a correct place where you will get a real reaction and what is happening in our country and different country in this Africa country. And today's reaction, I want to tell you that Martha Karua, the leader of one of the parties in Kenya and member of judges in High Court, was chosen to go in Uganda and to save Besigye na kuzungumza zaidi na kuweza kumtetea Besigye ambaye alikuwa mpinzani wa Museveni na aliweza kufungwa kwa kosa lisilojulikana. So guys, watch my video, then I will come for more reaction. But remember to like and even to comment on this channel. Please. That is my humble request. Is not a command. Thank you as you are doing so.
Even with the seat of authority, judges do remain human. And are affected by issues that affect other human beings. So my submission is that on that alone, the court ought to recuse itself. But that is not all. On the issue of denial of mandatory bail from the eyes of A1 and his colleague A2. And it's called mandatory bail for a reason, because upon a set of circumstances being fulfilled, the court has no alternative but to grant bail. And those set of circumstances is accused persons having spent 180 days in custody, which A1 is reminding the court how it dealt with the matter by stating that it had no record of the court-martial, the general court-martial proceedings. So even on that those issues tabulated without going through what the A1 directed the court, will the perception be that these three gentlemen can get fairness before this court? The perception is important because unless if subjects have confidence in courts of law, then law and order become under threat. The other very important issue raised is about the order from the KARUA court to the High Court. Because it's an order. The order was to the International Crimes Division. A division separate from the division in which my Lord serves and in which we are today. This is the High Court Criminal Division. The order was the file be sent to the International Crimes Division. The lingering question, how did the file find its way here? Those divisions are administrative, set up by His Lordship, the Chief Justice. Was there perhaps an order by the Chief Justice transferring it from one division to another? Or are the divisions of the High Court allowed to take away files belonging to another? And if that is the case, what is the impression that would arise in the minds of reasonable people? How did it land here and why? Is the question. My learned junior, Mr. Biribumbuka, says that we are perpetual complainers. I will say we are very consistent on issues of fact, on issues of law, and rules of procedure. On that, we are consistent. And if he finds fault with that, then it is unfortunate. We do insist on our rights where the law is clear, whether it's mandatory bail or an order committing the proceedings to a different division of the High Court. My Lord, the whole scenario to us signifies a pattern of erosion of the right to fair trial, and that is what I got from our client's long address to the court, that he feels the right to fair trial, even on elementary matters such as mandatory bail, has been eroded by whatever is happening, beginning with the illegal rendition from Kenya. So what I hear him saying is that this whole case is founded on illegalities, one illegality upon another. A court of justice should not have to act or give any color of right to illegalities. A court of justice should slam the door shut on illegalities for justice to be done. Finally, from me, not from our side, the courts failing to release them, even when the warrants of the court-martial expired. That is after the Kavasi Guruka ruling of 31st of January this year. Those warrants expired on the 3rd of February. Yet they were not released. They continued in custody. And the process continued going on without the courts acting on the illegality. That does make our clients aggrieved, and they feel that this case is a build-up of illegal actions. Not to mention the issue of territorial jurisdiction. The Constitution of Uganda is very clear. Courts of Uganda have jurisdiction within Uganda. The acts alleged were abroad. So even that itself becomes an illegality. Arrest without, it's 126, arrest without warrant in a foreign country, without due process. So those are the illegalities I heard our client going on about. So I would like I give way. I just want to end by referring the court to Article 129. It begins at 126, but the most instructive is 129. Judicial power of Uganda. 129. Courts of judicature. This is a court of judicature. Judicial power of Uganda shall be exercised by the courts of judicature, which shall consist. So what I want is just the word of Uganda, not of Kenya, not of any other country, just to indicate the territorial limits of your jurisdiction. So that when A1 says it is one illegality upon another, the court is able to grasp. I cede ground to my colleagues. I know that Lukwago and Kalibara and you.
May it please you, my lord.
We are ready here, and they have our instructions to represent us.
It is clear, yes. These three people you authorized were also here, and it is a simple procedure to me. Why don't you follow that procedure and then we proceed? We are not saying that we don't want these people to represent you. It is just a matter of procedure. That's what we want. Fulfill that and we proceed.
Can you at least grant permission to our senior counsel here to address you?
What are you advising on that one?
May it please the tribunal. The last time we adjourned,
Senior counsel, I have been requested to advise you.
Let me just state my case and then the
No,
tribunal can
I'm
decide.
still advising. I don't want also you really to. I know you are from a foreign country. Counsel Kwago, you are saying that court is following what I'm saying, but I'm referring you to Regulation 63 of our rules of procedure. I am mandated to advise court and all lawyers in this court on all matters of law and procedure. And Senior Counsel Masa KARUA, last time I advised that we don't have a tribunal. This is a general court martial established under the UPDF Act and recognized even under the Constitution. So anybody who is going to refer this court as a tribunal will be in contempt of this court. That is my advice, sir. We can hear from Senior Counsel.
Are you advising or making a ruling? I've been a judge advocate just like you, and you advise, you don't make a ruling. Mr. Chairman.
I have advised. Now you proceed. But we don't want the name tribunal in this court.
Mr. Chairman, the last time we adjourned was so that you could give time for me to get a practicing certificate. I now want to let you know that, you and members know that I do have a practicing certificate, which was issued to me this morning, to also indicate that the last 2 times we have been in court, because this is the 3rd time, you have had submissions from Elias Rukwago. He has been introducing all of us, including Ernest Karibara. It therefore means that it's within the knowledge of Mr. Chairman and the members that the team in court is representing Ms. Dr. Kisa Besigye and Obed Lutale. And we really are taken aback because even the permissions you have granted before on how we should enter the court and that we should come with our tools of trade, all have been flouted by the orderlies today. We have been subjected to very difficult conditions, back and forth, such that before you, we are so exhausted as not to be capable of properly representing them. We have also witnessed before this, before your very eyes, the assault of one of the team members. When we come before you, we feel protected by you. But today, that has been violated by the orderlies. If anyone commits a perceived offense, we expect them to be restrained, not assaulted. To be removed, not assaulted. I was at the back. I did not exactly see what happened. So we have serious issues we'd like to address you on, and we seek to be allowed to start normally, not to be taken back, to start registering, and we've already been before the court before. It doesn't happen that way. And it is unfortunate that the court is being informed to go back and forth. It becomes difficult. It's a very bad picture, even before they are accused persons, because will they expect justice? If every day we come, there is shifting of goalposts. We respectively urge you to grant us audience, which we already had, so that we are able to proceed. The word of mouth before the court from these 2 gentlemen is better than any written paper. If they say, oh, these are their lawyers, that is it. For purposes of your record, we can later furnish you with a complete record. For purposes of your record. But for purposes of, we will give you at the end of it. But because they now have told you we are their lawyers, do allow us to proceed. Otherwise, it may appear, it may be unintended, but it may appear that we are being denied audience and that the defense of these 2 gentlemen is being scuttled deliberately.
Now, Counsel, thank you for your submissions. I wish your colleagues would be behaving like you, so that we could now you can hear. These are lawyers also making noise. What is Look at you. Eh? Now I don't know. Are you helping the accused people or you are not helping them? You talked of that you revenge us with the required papers. And we talked about this the other time when we were here. Why didn't they fulfill that? Secondly, you are talking about the assault. You are not talking about the conduct of your colleague. What type of conduct is that in the court? I think we also need to behave, because we are not here to show that we are in uniform. We are not here to support. We are here for justice, nothing else. But the way we are conducting ourselves, I think it may not help us. Instead, it will be affecting the accused persons.
May I respectfully urge you to also detail the orderlies, because every day we are being met by different people with different standards. The first day, 4 hours of standing outside there. I have not even
I think, sir, we are going astray.
And today, allow me to make my submission, for which I may not require your advice. The court will require it. I am saying that we are being subjected to different standards every day. The first day, 4 hours of standing, we have not even recovered from that fatigue. Today, over 2 hours. The second day, the 10th of December, we had an easier time. Today, I am informed, because I was at the back, I couldn't see. All Aaron Chiza wanted was to come in and sit, and he normally sits here. Even if there is no seat, an advocate should not be stopped from approaching the court. It is the court that would direct anybody without a seat go out. So there is something wrong with the way the preparation of the orderlies, and we would urge that there be strict instructions so that there is no back and forth. Before, the 2 times we have come before this tribunal, we have had no complaints about the way that the court, you said court, I will use the term.
Honorable Chairman.
Sorry, yeah, it is not an offense. The way
Honorable Chairman, it is a contempt of court. I'm sure even senior counsel can be held in contempt.
But that's what I requested. Let us respect each other and we proceed.
Yes, I have already corrected myself, so I do not know what the judge advocate is complaining about. But what I'm saying is this, that Aaron Chisa should not have been stopped from coming in. I myself was stopped from coming in, and other lawyers on the 10th. We went to the back. We were then invited. But unlike me, Aaron Chisa is an advocate of the High Court of Uganda. He is known by the orderlies. So it looks like there was an intention to actually assault him. And we come here respectfully, we address the court, and we leave. And that's all that we need. How is it going to affect the 2 gentlemen on the dock when one of their lawyers is not there? May we respectfully ask for time to withdraw and confer with them so that we may now know what to do without one of us. Because each one of these lawyers has a specific task. The matter before you is the matter of life and death. That is why it has so many lawyers. We ask you respectfully to give us time with our clients.
Which time? Like
1 hour?
I think, sir, before you conclude on that, we have lawyers who never filed their practicing certificates. A current practicing certificate. Those who have not filed are not going to be part of this team until they file.
excuse me, but that one we are not reversing that. People who have fulfilled, we have given senior counsel the chance to talk. Honorable Kwago, you could sit first.
At least to be listened to. Mr. Chairman.
Honorable Kwago, just take your seat and put the mic down.
But at least a word before you make the ruling.
You see this, she's, senior counsel is talking of harassment outside, but what I have heard, partly it is caused by your people. That one I'm going to handle. I will talk to the security people. That one will be handled. But once we organize ourselves, because we want to know, yes, you are talking of lawyers, we are seeing them. But now, how can I know that this one is from this farm, this one is has what? How can I know? And this is the if you are not ready to follow the requirement, then you be there like any other person, or even you don't come here.
Mr. Chairman, I wanted to address you on that very issue. First of all, we already on record. The list was submitted. And indeed, you captured titulars of these advocates, their names, their law firms, and every aspect that was
What did we agree on last time?
Yeah, that's exactly what I wanted to explain, Mr. Chairman.
Do you have papers?
Can I explain, Mr. Chairman? One thing, what happened, because the stringent rules he's reading, the judge advocate, would require that the accused person append their signature on the instruction. And we have attempted to access them in Ruzira to process that in vain. Today, if I may tell you, Mr. Chairman, you can ask and cross-check with the prison's authorities if it is possible for anyone to access Dr. Chiza Besigye and obey duty. If you visited the Ruzira Maximum Prison, the only way you can talk to them is through a landline, a phone. They are at a distance, so how are they going to sign on those instructions? If you insist on that, it will be a perversion of justice. You'll be perverting justice, Mr. Chairman, because it's not going to practically happen unless you are saying that we do it right now, that we prepare a paper, the list is here, we can present it to them, they sign, we file it. If that can do, if it can suffice, we are ready to comply with that. But if we are to access them in Ruzira to sign instructions, that is not going to happen. The last thing, Mr. Chairman, he's insisting on PCs being filed with you. We are in a grace period of 3 months. 3 months. Right now, I have a right to practice without a renewed PC. Right now, until 1st March. So we are in January. We have all this grace period to process the practice certificate. I thought, as the advisor of this court, shouldn't even have raised this matter. It's totally very embarrassing that he's raising such a matter when he's supposed to be a senior advisor to this tribunal, General Court Martial.
Welcome back, ladies and gentlemen. Hope you have subscribed in this channel, you have liked and even comment on the channel, guys. So Besigye is I can say that is a opposition leader in Uganda, and Besigye was arrested kwa kusemekana ya kwamba anakiuka madini ya country ya Uganda, na Besigye akawa amefungwa hadi hajafungwa leo ama jana, hadi akawa amefungwa miaka, kwamba atahukumiwa kifo kwa sababu ya kukeuka kanuni ama kukeuka sheria za Yoweri Kaguta Museveni na mwanawe Mhonzi. Then Besigye akachagua Martha Karua kuwa lawyer wake, na Martha Karua alipofika Uganda, kwa hakika things were not good in Uganda because alikuwa embarrassing, akapata people who are wako against yeye, like they don't want to honor Martha Karua to be in that country. But Martha Karua fighted until akaingia kwenye koti na kumtetea Besigye, na as we are talking now, Besigye hataweza kunyongwa tena, bali Besigye ataachiliwa. But I can ask her a question. Why that Uganda, they always rule Ugandans people with one tribe, one family? When I talk about one family, it is the family of Yoweri Kaguta Museveni. You will understand by saying, you will understand when I say that family of Yoweri Kaguta Museveni, because those are surrounded Yoweri Kaguta Museveni. That is a circle. In that circle, the main is Museveni, but the surrounded people around Yoweri Kaguta Museveni is his own family. Sister-in-law, brother-in-law, my brother, my sister, my mother, my cousin, my uncle, those are the leadership of Uganda. And that's why if you want to remove Yoweri Kaguta in that seat, it will be hard, because those who surrounded Museveni is those who will support Museveni with a high rank by saying that this is our own. When we put the difference of political analysis aside, Museveni will remain our brother, our sister, our cousin, our father, our grandfather, our brother-in-law, our sister-in-law. So those are the questions, and that's why you can't defeat Museveni. And that's why Museveni said that I won this chair by blood, and someone who will come to rule Uganda, he must come in blood. So that is the reason why Yoweri Kaguta Museveni is ruling Uganda with those long time colonies. I can say that Uganda is still under colonialism, and those someone who doing that is Museveni. And you will agree with me that Martha Karua alikuwa pale, goes there to try to distract those things or to remove that mentality by saying that Museveni is the president of Uganda. Yes, everyone knows that, but the problem is that people who are in Uganda, do you think that they are happy with the leadership of Yoweri Kaguta Museveni? Automatically answer is no, because you heard that a courageous man who said that this Uganda, we love our country, but the problem is that no one can speak against Museveni. If you speak against Museveni, then you will face the consequences. Now you are bado tupo, yale Uganda yanapitia yale mambo ambayo walikuwa wanapitia mababu zetu walipokuwa wanapigania mataifa tofauti. Kwa sababu hautakubaliana nami ninaposema ya kwamba watu wanapomzunguka ama watu wanayemzunguka Yoweri Kaguta Museveni, hao ndio wako wake, na ndiposa utaona kwamba anamdhulumu Tundu Lissu akijua ya kwamba utaona pia Tanzania wanamdhulumu sana Tundu Lissu, na Tundu Lissu ni mkuu wa opposition kule. So hizo country mbili, Uganda and Tanzania, they have something in common. They do things like similar. Walimu wao, naweza sema kwamba mwalimu wa Yoweri Kaguta Museveni na mwalimu wa Samia Suluhu Hassan ni mwalimu mmoja. Na je, huyu mwalimu ni nani? Because utaona Tundu Lissu yuko ndani hadi sasa. As we are talking now, Tundu Lissu is under jail and under police management. And when we go in Uganda, utaona kwamba Besigye bado ako ndani hadi sasa. And that's why utaona Martha Karua ana fight justice ya hawa watu ipatikane. And who will help Tundu Lissu and Besigye to get his or their justice? That's why utaona kwamba wanajaribu each and every time kutoka kwa ule uzingizi ambao wamekuwa wanalala, lakini vimekuwa vigumu kwa sababu viongozi ambao wamekalia hicho kiti wanaongoza hayo mataifa mawili na ule uzito na kusema kwamba this is my country, I have authority and that power to do anything that I want. That's why you will agree with me by saying that jinsi Martha Karua alifika pale, alikuwa humiliated, akawa anaambiwa kwamba this is the case of Uganda, leave Uganda to solve their own problem. But the law and high rank that Martha Karua had, it forced and it will make Martha Karua to go in Uganda and solve conflicts, because that's the conflict. You can't tell me that you are Besigye. You just imagine, that's an old man. Unamtesa, unamdhulumu. Why? That's a question. But if you are watching my video and you are being you liked those videos and you want to support me, please I want to request you to support me by subscribing on this channel, to like on this channel, and even to comment on the channel. Thank you. God bless you so much. Yours, MIKEANN'S Reaction.